in accordance with Section 71(4) of the Office of the Special Prosecutor Act 2017, Act 959. One, the history of Mr. Owusu with respect to criminal activity, the level of cooperation Mr. Owusu exhibited during the investigation, the likelihood of obtaining a conviction if the case proceeds to trial, the probable effect on witnesses of a trial, and the need to avoid delay in the disposition of other pending cases. 3. National Petroleum Authority. In November 2024, the OSP commenced investigation into suspected corruption and corruption-related offenses in respect of the operations of National Petroleum Authority, NPA, and the activities of some of its officials. The OSP investigation has revealed that between 2022 and 2024, some high-ranking officials of NPA devised and implemented a corrupt scheme of using public office for profit through threats, intimidation, coercion, suggestions, bribery, and inordinate regulatory duress to obtain for their personal benefit large and other entities under their statutory regulatory, licensing, oversight, and monitoring in the petroleum downstream industry. As at the close of business on 30 May 2025, the OSP had uncovered, through tracing and trailing, an amount of 280,516,127 cedis and 19 pesos, being proceeds of the corrupt scheme, some of which has been used by the perpetrators to acquire identified and traced apartments, suites, houses in country and abroad, 22 fuel haulage trucks, and the incorporation, acquisition, and operation of oil marketing companies to compete with the oil marketing companies they were regulating. The OSP, before the end of June, would file criminal charges against the first batch of the perpetrators and complicit oil marketing companies and their officials. Upon filing, we will brief you in detail in respect of who did what, who acquired what, and what has been recovered. 4. Kenneth Nanayao Ofori Atta. We recall that by a letter dated 24 June 2025, Kenneth Nanayao Ofori Atta, a former Minister of Finance, was informed that the OSP had commenced investigation into suspected corruption and corruption-related offenses regarding cases in respect of which the OSP considered him a suspect. Further, he was directed to attend in person the OSP on 10 February 2025 for interviewing. Mr. Ofori Atta was out of the jurisdiction at the time. By a letter dated 31 January 2025, Mr. through his lawyers that he was out of the jurisdiction indefinitely on medical grounds, and that the firm will notify the office of his arrival in the country in aid of rescheduling his personal attendance at the OSP. Further, the lawyers offered its willingness to provide the OSP with any information we may require to aid in the investigation until his arrival in the country. Upon receipt of these representations from his lawyers, the OSP, by a letter dated 5 February 2025, informed Mr. Ofori Atta that the OSP did not need or required notification from his lawyers of his future arrival in the jurisdiction. The OSP acknowledged his lawyers' offer to provide us with information in aid of the investigation. However, the OSP insisted that his personal attendance at the OSP was required. The OSP directed Mr. Ofori Atta to indicate by close of business on 10 February 2025 a reasonable date of his return to the jurisdiction and attendance at the OSP. The OSP warned him that if he failed to do so, The OSP will take all necessary legal steps to secure his return to the jurisdiction and attendance at the OSP at our own choosing. Mr. Ofori Atta failed to indicate a reasonable date of his return to the jurisdiction upon the expiry of the 10 February 2025 deadline, except to still persist in his expressed intent of remaining indefinitely outside the jurisdiction by the transmission of his lawyers of a purported and brusque medical letter on 10 February 2025, which only sought, in effect, to state that he may undergo a possible surgical intervention in March 2025. In the considered opinion of the OSP, that medical letter could not be held to be a disclosure of a reasonable date of Mr. Ofori Atta's return to the jurisdiction and attendance at the OSP, since it merely indicated that there may be a possible surgical intervention may or may not occur in March. The letter, which was in no way a medical report, neither stated nor demonstrated that Mr. Ofori Atta was a travel risk or that he was an invalid who needed around-the-clock intense medical attention to the point that traveling to the jurisdiction would endanger his life. Upon the expiry of the 10 February 2025 deadline, the special prosecutor publicly declared Mr. Ofori Atta a wanted person and a fugitive from justice on February 2025, on the ground that his avowed posture of remaining indefinitely outside the jurisdiction without indicating a reasonable time of his return to the jurisdiction showed clearly that he had no intention of voluntarily returning to the jurisdiction. By a letter dated 17 February 2025, Mr. Ofori Atta's lawyers transmitted to the special prosecutor a communication laced with vituperation and designed variously as a denigration of the OSP, a lecture on their suppositions as to the mandate of the OSP, a threat of legal action, a sort of homily as to its affairs, an attack on the person of the special prosecutor, and a suggestion that the special prosecutor had embarked on a personal vendetta against Mr. Ofori Atta without disclosing the alleged series of retaliatory, vengeful, or hostile acts the special prosecutor had directed at him, or alleged exchange of such acts between Mr. Ofori Atta and the special prosecutor. Crucially, a 17 February 2025 letter from Mr. Ofori Atta's lawyers failed to indicate a reasonable date of Mr. Ofori Atta's return to the jurisdiction and attendance at the OSP. On this, the OSP, by a letter 17 February 2025, reaffirmed and restated to Mr. Ofori Atta that he remained a wanted person and a fugitive from justice. The OSP further stated that this tag would remain until he indicated a reasonable time of his return to the jurisdiction, with the necessary and reasonable assurances of abiding by his indicated reasonable time, or until such time that the OSP enforces return to the jurisdiction and attendance at the OSP, whichever came first. By a letter dated 18 February 2025, Mr. Ofori Atta's lawyers communicated to the OSP that he was scheduled for a possible session in the United States on 20 and 21 March 2025, and further that taking the date of the possible surgical intervention into account, he would require a recovery period of 6 to 8 weeks. On this basis, his lawyer stated that he should be able to return to the jurisdiction between 14 and 30 May 2020. On the day, by letter dated 18 February 2025, the OSP graciously acceded to Mr. Ofori Atta's request to return voluntarily to the jurisdiction between 14 and 30 May 2025, as the office deemed the indicated recovery period reasonable in the circumstances. Consequently, the OSP removed Mr. Ofori Atta's name from the list of wanted persons pending his voluntary return to the jurisdiction based on his own indicated dates. Consequently, the OSP directed Mr. Ofori Atta to attend the OSP in person on Monday, 2 June 2025 at 13:30 GMT for interview, which is today. The OSP emphasized that if he failed to voluntarily return to the jurisdiction within his stated dates, and if he failed to attend the OSP on the rescheduled date of Monday, 2 June 2025 at 13:30 GMT, his name will be re-entered on the list of wanted persons, and the OSP will consider him a fugitive from justice, whereupon the office will take all necessary legal steps to secure his return to the jurisdiction and attendance at the OSP at our own choosing. Then, by a letter dated 28th May 2025, Mr. Ofori Atta's lawyers informed the special prosecutor that a medical expert has diagnosed Mr. Ofori Atta with cancer and has earmarked 13 June 2025 for surgery, for which reason he would be unable to return to the jurisdiction as scheduled. His lawyer stated that to the knowledge of the OSP, this change in circumstances has been brought to the attention of the court, for which Mr. Ofori Atta is presently pursuing a human rights claim against the OSP and the special prosecutor. His lawyer stated further that in order not to hold the office back in the performance of his function, they had Mr. Ofori Atta's instructions of his readiness to go through video recorded interview for the purpose of eliciting his caution statement. His lawyers offered to meet the special prosecutor in person or approach the bench for the purpose of viewing Mr. Ofori Atta's biopsy report, whichever suited the special prosecutor. Now, ladies and gentlemen of the media, this is where we are now. And let us step back a bit from the 28th May 2025 letter from Mr. Ofori Atta's lawyers and place the matters in their proper context. I have intentionally went through a tedious timeline. The letter from Mr. Ofori Atta's lawyers, dated 18 February 2025, clearly indicated that the possible surgical intervention to be performed on him was to occur on 20 and 21 March 2025, upon which reckoning the OSP carefully considered the recovery period and indulgently pushed Mr. Ofori Atta's attendance at the OSP to 2 June 2025. Therefore, Mr. Ofori Atta had a duty to promptly inform the OSP of any fundamental change in his medical circumstances on 21 March 2025, when the advertised surgical intervention was not performed, to enable the OSP reschedule a new date of his attendance at the OSP to accommodate any such material changes in his medical condition and treatment itinerary. Mr. Ofori Atta has known, at least since 21 March 2025, that no surgical procedure was to be performed on him in March. Yet, he purposely sat by indolently and chose not to inform the OSP of such fundamental changes in his circumstances. Instead, about 67 days after learning of the alleged changed circumstances around 21 March 2025, Mr. Ofori Atta elected to spring a surprise on the OSP on 28 May 2025, just 6 days before his scheduled attendance at the OSP, by offering to undergo a video recorded interview and a viewing of his biopsy report. Now, back to the 28 May 2025 letter from the lawyers of Mr. Ofori Atta. As I said, this is where we are. By a letter dated 30 May 2025, the OSP declined Mr. Ofori Atta's offer of video recorded interview for the purpose of eliciting his caution statement. This office has always insisted on his personal attendance, and we have indicated clearly to him that we are unwilling to waive it. If we were amenable to taking any such statement from Mr. Ofori Atta in absentia, we would have done so in February and not waited to 2 June 2025. We want him here physically, and we insist on it. A suspect in a criminal investigation does not pick and choose how the investigative authority should conduct its investigations and the method suitable to him and his convenience. We will not countenance such conduct, not in this case or in any other case. Further, the OSP has declined Mr. Ofori Atta's invitation to view his biopsy report as we consider it a pointless exercise. This is because it is common learning that the biopsy report contains nothing more than a conclusion upon the removal and examination of tissue, cells, or fluids from a living body that some disease or malady was indicated in the samples taken. A biopsy report is not an expression of a reasoned medical opinion that the subject of the report is an invalid and unable to travel, as Mr. Ofori Atta seeks to suggest is his condition, and for which reason he says he cannot return to the jurisdiction. This much is clear. Since 24 January 2025 till date, Mr. Ofori Atta has failed to show any medical report. I underline, he has failed to show any medical report which suggests that he is a travel risk and unable to return to the jurisdiction by reason of his medical condition. It has all been his say-so, his singular say-so. Therefore, the OSP views Mr. Ofori Atta's lawyer's letter dated 28 May 2025 as an expression of utter bad faith on the part of Mr. Ofori Atta, and it confirms our long-held, well-considered opinion and conclusion that Mr. Ofori Atta has no intention of voluntarily returning to the jurisdiction and to attend the OSP. Further, this office is unaware of his purported information to the court, whether orally or by filed processes, of the alleged change in his circumstances. Today is Monday, 2 June 2025. It is more than 3 hours past the scheduled time of Mr. Ofori Atta's attendance at the OSP, and Mr. Ofori Atta failed to attend the OSP today. Mr. Ofori Atta's conduct is totally unacceptable and a baleful spite at law enforcement and criminal investigations. It ends here. It ends today. We will no longer accommodate him. Consequently, the OSP redeclares that Mr. Ofori Atta is a wanted person and a fugitive from justice. His name is hereby re-entered on the OSP's list of wanted persons. The OSP will take all necessary legal steps to secure Mr. Ofori Atta's return to the jurisdiction and to answer to the criminal inquiries against him. In pursuance of this, about 30 minutes before this briefing, I triggered processes for the issuance of an Interpol red notice for the location and provisional arrest of Mr. Kenneth Nanaya Ofori Atta in whichever jurisdiction pending extradition or his surrender. Around the same time, I dispatched a request for extradition processes to be instituted for the provisional apprehension in any jurisdiction in which Mr. Ofori Atta may be located or found, and his extradition to the Republic of Ghana. The OSP will prefer criminal charges in the courts against Mr. Ofori Atta in due course, whether in absentia or otherwise. The principle upon which we proceed is that no person, regardless of title, regardless of status, regardless of medical condition, is beyond the reach of inquiry by the OSP. Thank you for coming. If you have any questions, I'll be prepared to answer them. If you don't have any questions to Mikayepa and Kamiko. Yes, sir.
My name is Hansen Ajaman. I work with Channel 1 TV City FM. On the issue relating to the former finance minister, many will wonder...
I talked about 4 cases. Why did you go there?
Many will wonder what difference will his presence make for the OSP? Because, again, as you've indicated, you have even the option of trying him in absentia. And if you have enough case against him, you can go ahead even without his presence. What exactly is the OSP interested in getting the finance minister back? Relating to the NPA case, you said that you will give out the names of who did what at the right time.
When we file.
Yes, when you file. But I remember at the last press conference, you had singled out the former CEO of the NPA in the person of Mustafa Hamid. It's fair to ask, is he part of the issues you've outlined here today, or his is different? Because he had come out to say that you had not even engaged him, you've not notified him of
is that so?
Yes, of any form of interrogation, and he's not done anything wrong. And the final thing with Cecilia Dapa is it that you disagreed? Because we know that Yoko's stance on the matter was based on an advice from the former Attorney General, who says that if you look at the reading of the law, money laundering should be on a predicate offense. Is it that the Office of the Special Prosecutor disagreed with that legal view?
Can I answer? Then we go.
So let's get a bit more. Is there any more question so that we are clear?
You know, Sam, let me override you. Sometimes when it's fresher in mind, the responses come quick. By the time I take 20 questions, I'll forget the meat of what he said. What is his presence? What will his presence do? Now, as I said, in due course, we will charge him, whether in absentia or otherwise. Imagine we charge him in absentia and we get a conviction against him. Who are we imprisoning or who are we fining? Say, to get a simple mathematics of it. As I said in my brief, a suspect in a criminal matter does not choose how the investigative authority should go about investigating him. When he wants to appear, when he decides to appear, in what way he wants to appear. We do not take caution statements online from a foreign jurisdiction. And who says I even want to take a caution statement from him? He is the one who is dictating, he wants to dictate the process. You get it? And we have always insisted from the onset that we want him here. Legally, I will say that to you. But there's a far more grave reason why we need him here. And since the investigation is still going on, it will be rounded up soon. I will not be able to disclose to you. But as I said, that possibility, if we take him to court, if he is convicted, if he is sentenced to some number of days, months, years in prison, in absentia, what would we have done if we didn't to bring him here? Mind you, this office investigated a former president. The former president was served at the time with the same kind of directive to appear before the OSP. We didn't have to be chasing the former president around the world. How much less the former Minister of Finance? What is so special about Mr. Ofori Atta that he thinks is unique and should be treated like a king? As I said, we have indulgently accommodated him. It ends here, it ends here today. This rigmarole is not going to go on anymore. We are not going to accommodate such conduct again. We've granted him so long a rope, it's tied him up, and it's done. Our NPA, yes, we singled out 3 individuals on 12 February. And you said one said he hadn't been engaged. Let me ask my operational directors, should I review? They say no. So when we file, as I said, we will go through, we will brief you who did what, who took what, who acquired what, and what we've been able to identify and what we've been able to retrieve so far. We've retrieved some things too. Cecilia Dapa, when in May 2024, the then head of IOCO returned the docket back to the OSP. The OSP didn't comment, did it? We didn't express an opinion as to whether we agreed with its conclusion or otherwise, or as to whether we agreed with the Attorney General then. We had investigated the matter. We had hit a wall in terms of our mandate. We were seeing things that looked like in the province of IOCO's mandate. So we sent the docket to IOCO under referral, under provisions under our act, for them to go to court, because we didn't think the docket was ready for prosecution. What we suggested is do your own investigation. Commence your own investigation to see, you will see conclusions of what we think they are seeing. They returned it to us wholly and said they didn't have any basis upon which to commence investigation. Now a year later, there's a new leadership. The new leadership has requested for the docket that they want to review and commence investigation. So we've given it back to Yoko under the new leadership, and we have promised them our full collaborative support and partnership in respect of their review and investigation. Shouldn't you be happy that someone wants to take action and not someone who just closes a file and says, I can't even open up to investigate? Yes. Yes, sir.
Right.
When I see you this morning.
Perhaps on TV. Perhaps
means you were on TV this morning.
No, maybe alone in the afternoon. On that May 28 letter, lawyers of Ms. Ofori Atta wrote to you, where they, amongst many things, disclose his health condition. Did they by chance communicate if there was a possible date to which he could honor this invitation at a subsequent date? That's the first question. The second is, when you wrote back rejecting the explanation that had been offered, reason for which he cannot make that appearance, has there been yet again another response from the lawyers of Ms. Ofori Atta? Because there is also the arguments being made that in all of your actions you've been adversarial, and like my colleague had mentioned, if indeed you have a case, you should have filed it by now.
Just as has been his style, 28 May 2025 request to us contained no suggestions of a date. Mind you, all this while we beat the date out of him. You will recall, he never suggests a date. He just says, I'm unwell, I cannot come. When I come in, my lawyers will inform me. It's a police, police. So what I say? Yeah. When the law enforcement agency and the prosecutorial investigative authority wants you, you do not tell that investigative authority that you choose to come when you want to come. It is a criminal inquiry. You are a suspect. You've been told clearly. Because upon arrival here, we may choose to arrest you. It is not for you to choose and pick what should be done. Now, I signed the letter for dispatch on 30th May. That is on Friday. And so we've not had any response. And so we've been adversarial. I almost went to the lecture room. You know my first love is lecture. Once again, investigative and prosecutorial authorities are adversarial by nature. If I were to challenge you to read the entire scheme of affairs in Act 29, LI 2374, there is not a single provision there which is friendly. Read Act 29 itself, the mother of criminal jurisprudence in this country. There's not a single friendly provision because it is criminal. In criminal law, there's no friendliness. And that is principle. That is policy. Situate it in our context. We have been adversarial since 24 January. We kept pushing. We kept pushing. We've been indulgent. Because, let me speak to you again, so when someone says they are not well, you listen. But is it on the say-so of the person in this modern era? If you want to take an excuse duty for your employers, do you show up at your boss's desk and just say, I have cancer, I can't come to work the next 4 years? Is that what you would do? Would your bosses take you serious? You probably may be fired on the spot. How much more in a criminal inquiry? You are dealing with a criminal investigative and prosecutorial authority. And every time you show up and just say, just singularly, on your say-so, that you are unwell, you cannot come. Mind you, in my brief, I said, from 24 January till now, Mr. Ofori Atta has not produced any medical report. A semblance of it was that medical letter, that 5-line medical letter that said he may undergo a possible surgical intervention in March. And from March, count the days till 28 May. From 20 to 21 March, when he said he was going to have the possible medical intervention, surgical intervention, upon which reckoning we indulgently said, oh, take some of the days, recuperate. So he suggested he will come between 14 to 30 May. He said, oh, take a few more days, come on 2nd June. How friendly can we be beyond this? After accommodating you, you sat by for at least 67 days when you knew your condition had changed, and you never bothered to tell the OSP that there's been a fundamental change in your condition. You're acting in bad faith, utter bad faith, and for which reason we have stopped this party. Can we hear the lady? Hoarse voices. Let me hear something more interesting.
Thank you very much.
Including mine.
Special Prosecutor. My name is Mami.
Did you hear that?
I'm with Joy News. My first question is, the letter you received from Mr. Ken Ofori Atta's lawyers indicating that he's unwell and still unfit to present himself physically for interrogation. Have you independently verified the information that has been given to you, at least know exactly where he is in the US and in which state he is in? Also, you declared him wanted at a point where he doesn't return into the country. At which point are you going to begin extradition processes? Also, under the Mutual Legal Assistance Act, Act 807 under Section 42, it provides, opportunities for hearing of the accused person via video conference, one which the lawyers of Ken Ofori Atta have proffered. Why are you not considering that?
It's all in contest. It's all in contest. In my briefing, I said on extradition processes, we commence it today. Because we had to wait. Maybe there would have been a change of mind from 28 May till now. You never know, because you don't hasten to take such decisions. Maybe from 28 May to today, 2 June, over the weekend, he may have emplaned and arrived in the country. So you wait for your own stipulated expiry date and time to elapse before you commence action. So I said, 2 minutes before I came to the briefing, triggered the extradition processes with the right authorities. Around the same time, double red notice for his location and provisional apprehension wherever he may be found. Now, you talk about MLA. Sorry, first you asked whether we have independently verified whether he was unwell or not. No. You do not spend state resources and time chasing after ghosts. In this sense, when the person has not represented to you by any medical report or opinion that he is so unwell that he cannot travel, he is so unwell that he cannot come to the jurisdiction, you do not go wasting your time verifying. For the law enforcement agency, it tells us that he's been untruthful. And that is the reason why we've been at him since January, because we do not believe what he's saying. You get it? And it is not for us, the law enforcement agency, the prosecutorial investigative authority, to establish his medical condition. For us, what the law requires us to do is, if we're investigating suspected corruption and corruption-related offenses, and you are a suspect, we bring you in. When we find you, then we assess your situation to see if you should even go through such a process, if you should even stand a trial by reason of your medical condition. Look, even persons who have been convicted and imprisoned, when they fall so unwell, and they taken to the hospital. That's why I said in P earlier that but the person has to show you that he is really so unwell that he cannot travel. And there are two things. As I'm standing here, you do not know my ailment. As you are sitting there, there may be some ailment which afflicts you, which I do not know. But merely by looking at you, I cannot tell that, oh, you are suffering from this or that or that. What tells us is what I told the first gentleman, a medical report. He's not the only one who's been in the US. It's not the only one who's been to medical facilities in the US. When US medical facilities are communicating with law enforcement, we know the form in which they come. A hospital administrator goes through a tedious process of detailed analysis of his condition to come to a conclusion that he is unfit to travel, and so he shouldn't be made to travel. That is when a law enforcement agency considers things like MLA processes, but not on your say-so, not by way of a biopsy report. Once again, a biopsy report in street language, it is merely like a lab test. That shows you have a certain condition. So in his contest, since it's indicated that it says he has cancer, it will be a removal of some tissue or fluid to test whether the tissues put in the cassette indicate cancerous cells. It doesn't mean that he's dying tomorrow, God forbid. It doesn't mean that he is so unwell that he can't travel. You know how many people are walking around with cancerous ailments, but they still show up at police stations and law enforcement agencies. That's why I asked the very first questioner, what is so special about Mr. Ofori Atta that he thinks that he can lie on his bed somewhere and say on his say-so without any evidence that I'm unwell, I can't show up? Conclusion, he won't come voluntarily. And so we end this process of accommodating him and put him back on the wanted list. Yes. Yes, sir.
Thank you very much. My name is Ohina Ponsa, and I work with Adom TV. You wanted Ken Ofori Atta in person. Is it that our laws do not permit trial in absentia? Is it the case that all the documents that are presented to you by Ken Ofori Atta, you seem not to have, it does not meet your threshold? Is it also possible that OSP will elect to go through the process or the trial, and at the end of the day, if the court listens to you and upheld in your favor, the court declare, or the court will put him to a place that he is supposed to be put, rather than it appearing that the SP or the OSP is becoming a judge in his own court? Thank you.
Yes, I would also want to ask you a question. Is this the first time that someone in our country has been declared wanted? Is it? All the persons previously declared wanted before him, were they human? Or they were not human? He is the only human. There's nothing special about this. That is all I'm pointing at. There's nothing special. There's nothing secretive or esoteric about it. It is just a simple legal process. Law enforcement agency wants you, you show up. If you see the gentleman standing by you, if he comes to you to say that you are under arrest, and you do not go quietly with him, what will happen? He will enforce it. If he doesn't reduce the length of one of your your legs and hauls you along with him. That's all I'm saying. There's no choice about you responding to criminal law enforcement. See, this video conferencing, this is not a civil inquiry. This is not a taking of a deposition in some matter before which you are filing before a court or not. Mind you, we are still in the investigative stage. We haven't filed yet. So everything now is under the purview of the OSP. You get it? Before we go to court, if the court says some emissaries should be taken there to question him under the largesse of whichever authority in whatever jurisdiction he may be found, that's fine. But for us doing investigations, we need to find our criminal suspects. We cannot just sit here and treat things like you are the same person who will turn around and say, We are treating some harshly, and we are sugarcoating others. For as far as we are concerned, Mr. Ofori Atta is not special. I will repeat. We investigated a former president. Have you forgotten? On 8 August 2024, I came right in this room and made told Ghanaians our conclusions and our findings. A former president. He was served with the same processes. He showed up. I'll repeat again, much less a finance minister, a former finance minister. The OSP stands for this. We do not regard persons. We do not regard titles. We do not regard your station in life. Everyone is the same to us. As we have set the precedent of investigating a former president, no one is beyond our purview. Everyone is fair game if we think you are a suspect in a criminal inquiry. Trial in absentia. I indicated so that we've triggered the processes for his enforced return back to the jurisdiction. By the time we are ready to go to court, he is still not here. We will file. If we commence the trial, he is still not here, we will commence the proceedings. He can choose to be there, wherever he is, if we haven't found him yet, if we have not enforced his appearance before us. See, criminal proceedings are not to be taken lightly. You respond to them. Even civil proceedings. If you fail to respond to civil proceedings, you will be sitting in your office or home one day and processes will be served on you that you've lost your house. Just because you sat by and didn't respond. And criminal proceedings, now I'm beginning to feel as if I'm in a lecture hall at Legon. With criminal proceedings, you stand the specter of losing your freedom, of losing something valuable to you by way of a fine. And that is no proceeding to joke with. Can I go now? Which is? Oh, documents. Are we a judge in our own cause? We are looking for someone to apprehend, and you're asking whether we are judge in our own cause. If we are judge in our own cause, it means the law says we should be a judge in our causes, but it cannot be the case. The law gives us the mandate to investigate suspected offenders. The law gives us the mandate copiously by spelling out our investigative powers. This is all we are doing. Mind you, we are performing a statutory function of investigations and likely prosecution. We haven't rendered any judgment on him, have we? Have we said he's guilty of one offense or the other? We haven't said that. We are only saying we have accommodated him enough and we are not going to go further. He is now a wanted person again and a fugitive from justice. That's the last, right? Let me take the one who hasn't had a go. Yes, sir.
I'm Isaac Abila.
In your head or not vigorously. What do you disagree with? Let's discuss.
I'm Isaac Abila with the EIB network, and my
EIB.
My question is: had Ken Ofori Atta duly communicated to the OSP at a reasonable time with the update on his alleged surgery date? How much more time would the OSP allotted to him beyond June 2?
Okay, so this is in theory. And in theory, let me answer. In theory, as I said, in practice, he sat by for about 67 days. When it became apparent to him that there will not be any surgical procedure in March, you sat down from 21 March through April, through May, then 28 May, 8 days before you are supposed to show up, you say, I'm on the verge of death, I can't show up, on your say-so. From the trajectory of events, from the timelines, from our conduct, it should be clear to everyone that we have been very indulgent and accommodating, even to attract the air of Ghanaians that we were treating him with kiss gloves. I lie. I've heard talk. Mr. Boesiako is going through some private hell. And why is Mr. Ofori Atta being given such a leeway? That is not what prompts our actions. But I'm just saying, our conduct has been to the effect that if you, once again, let me say it in Twi, so when the person communicates to you with evidence that he is unwell, that he is unable to travel, that he is unable to move, why do you insist that he must come on a specific date? But when he said to us that, on 20 and 21 March 2025, there will be a possible surgical intervention, then we carefully considered a recovery period after 21 March 2025. Give it 6 weeks, for instance. But we gave it 8 weeks. And we added more days to it, by which time you should have recovered. What prompted us to give such a leeway from 21 March? No, from 17 February, 17, 18. Communicated to us, and not in this bad faith way of communication, that indeed is unable to move, he is a travel risk, he is an invalid. We would have accommodated him, but this is utter bad faith, and we won't go on this trajectory again. That's the last one. He's been dying to ask his last question. They say prime time is over. You see, when I talked about extradition, please let me answer. This is crucial. See, when I talked about extradition, I said something. I didn't limit it to one jurisdiction. Because the request for extradition was in any jurisdiction he may be found. As we are talking now, he says he's in the U.S. Are you sure he's in the U.S.? So if you are tunneled vision and limited to the U.S., you do an extradition request for the U.S., so many questions will come. You have an extradition treaty with the U.S. Is the U.S. amenable to bring him? What if he's even moved from the U.S.? What if he's in South Africa? How would you know? So you throw your net, and that is why the Interpol Red Notice is crucial. Goes to all 196 or so parties to it. And wherever he may be found, provisionally apprehend him, and then we begin the process. He may choose to surrender and come quietly. So those are the considerations that go into extradition. Thank you so much for coming, and have a nice evening.
Welcome to you.